Yes, hello everyone, and today we are going to discuss about the topic about the Industrial Dispute Act 1947. And here, as we are going to discuss about that is introduction to the term of Industrial Dispute Act 1947. An industrial dispute may be defined as in conflict or difference or opinion about difference between the management or and the workers on term of the employment. It is a disagreement between an employer and the employee's representatives. Usually, every trade union's overpay of other working conditions can result in industrial actions. Where any industrial disputes occurs, both the parties, that in the management and the workmen, try to pressurize of each workers. The management may resort to lockouts while the workers may have resort to strikes, picketing, or groves. The disputes generally arise on accounting on poor wages, structure, or the poor working conditions. And here we are going to discuss about the very important the term of industries. Industry. The industry means any systematic work carried out, a systematic activity carried on by the corporations between the employer and his workmen is said to be as an industry. And here, what does it mean by the term industrial disputes? So disputes may, given as indiscretions may occur between the management with the workers, or the workers with the management, or the workers with the workers. This word is said to be as in disputes. Normally, the disputes may occur by the first cases the employer and the employers, or the employers and the workmen, or the workmen with the workmen. This is we call as in that is given as industrial dispute. And what are the main objective of this industrial dispute is to secure better conditions of the work and ensures the decent standards of the life to the workers. Objective number two, it substitutes the arbitration and the fair negotiation instead of the lengthy trial before the court of the law. Objective number three, it provides the preventive measures against illegal strikes and the lockouts. Objective number four, it also gives relief to the workers in case of layoff and retrenchment. Objective number five, it promotes the collective bargaining of the related to dispute forums. Objective number six, it restricts the closure of an establishment. And what are the major causes of industrial disputes? The first cause is there is many petitioners that comes under the dispute forums. The first petitions may related to the wage and allowances, and cause number two, that is industrial dispute may arise based upon the bonus schemes, and the next third one is termination of big services without prior intimation, and cause number five, if there is any indiscipline on the violence may happen between the workers. And point number cause number five, and what are the hours of the work, and what are the leave to be provided for the workers, and if for some other such reasons that is related to and factories. So these are the major causes may happen by within the Industrial Dispute Forum Dispute Act. And very important is here and list out the authorities and representations established under Industrial Dispute Act. The first important authorities there are the some few board to be assist in under the Dispute Forum Dispute Act, and list all such committees. So these committees some get a queries and find out there is a resolution for any kind of set of the problems that arise from the factories. So first committees is named as a work committee. Committee number two was there is a board, that is a board we call as a conciliation officer. And point number, that is a board number three, that is a authority number three is the board of conciliation, and board number five the court of inquiry, and the board number five that is the labor code, and the board number six that is given as industrial tribunal members, and board number seven is that is national tribunal members. So these are all the some few authorities may represented some such a get up the queries that related to industrial dispute forums. So work committees and conciliation officers, board of conciliations, and court of inquiry, and the labor code, and national tribunal members and national tribunal members to be associated to find the better solution for the workers in respect of any issues may arise from the worker sides. And if there is any strikes, and if there is be strongest sense to be happen by within the industry factory, that is given as strikes. So strikers we call as in where any number of persons break the employment of the agreement or refusal to work with the engagement of the work is called as a strike. So what do you mean by that? What is the prohibition of the strikers? So every employee who have been working in a public utility services can go for strikes without giving the notice of the strike within 6 weeks before the striking. And next one is without giving the employer notice of the strike and within 14 days of such giving the notice. And define the term as a lockout. Lockout means any temporary closing of the placement of the employment, a place of the employment or suspension of the work or refusal by an employer is said to be a lockout. So in this session we have discussed about that is introduction to the term of Dispute Act 1947. Thank you all. Thank you.